So again, it's my pleasure to welcome everyone to our second seminar today. It's wonderful that both of our speakers in the non-residential scholars program for Ukraine today are scholars who focus on the environment and scholars who are supported by Michigan State University in their project participation. So welcome everyone. And I'd love to introduce our second speaker today. It's Lesia Danyliuk, who is candidate of science in law, and she's also associate professor of the Department of Labor, Environmental and Agrarian Law of Vasil Stefanik Precarpathian National University. The title of Dr. Danyliuk's presentation today is Legal Protection of Environmental Rights and the Environment in Conditions of War. So really looking forward to your talk, Dr. Danyliuk, and the floor is yours.
Thank you very much. First of all, thank you, Sarah. Thank you, Svetlana, for your managing of this program and all your team for supporting. And now I will start my presentation. Okay. My name is Lesia Danyliuk, and I am the Associate Professor of the Department of Labor, Environmental and Agrarian Law of Vasil Stefanik Precarpathian National University. And thank you, Indiana University and Big Academic Alliance for such program. And also thank you, Michigan State University for supporting my project. My project includes question of environmental and war, environment in condition of war. Also, a lot of questions in my project will include problems of restoration of Ukraine, new environmental policy of Ukraine in post-war period. But today I'd like to talk about legal protection on environmental rights and environment in conditions of war. And as I understand, all of us are presenters of different branch of science, and maybe for some of you it is important to emphasize which environmental rights we have, all of us. And first of all, I'd like to say that according to Constitution of Ukraine, every citizen of Ukraine has the right to an environment that is safe for their life and health, right to compensation for damage inflicted through the violation of this right, and the right of free access to information about the environmental situation. And also, these environmental rights are defined in international law, in European legislation. For example, we know such documents like Aarhus Convention, Rio Declaration, and all these documents defined these environmental rights. For example, Aarhus Convention, which is gold standards in this question, defined the right to free access to information, right to participation in decision-making procedures in the sphere of environment, and right to protect for protection of environmental rights. So, just a moment. Also, it's very important to talk about the right to a safe environment and what does it mean, safe environment, how to determine when environment is safe or not. And also there are different documents in national, European, international level. And when we talk about Ukrainian national mechanism, of course, they are based on different international standards. And for example, we can see one of the article of law of Ukraine on protection of environment. According to this article, environmental safety should be understood as such state of the natural environment which ensures the prevention of the deterioration of the ecological situation, of the occurrence of danger for the human health. And
Lesia,
yes,
I'm sorry to interrupt. I'm not sure. Are you meaning to be scrolling through your slides? We're not seeing.
yes,
Okay, so I think maybe you could stop sharing and then make it full screen, because we're not seeing your slides advance, unfortunately. Sorry to interrupt you.
okay, thank you. Maybe I will try in such regime.
Is there a way to make them full screen, Lesia?
Yes. Do you see?
We see the slides, but they're quite small.
It's small. Okay. I will try to stop one more and thank you. Mhm.
Натисніть на цю піктограму спочатку.
Спочатку так, натисніть,
Ну,
пані.
натисніть на неї, на цю піктограму спочатку.
Цю, так?
Натисніть на спочатку, пані Лесі.
В лівому верхньому куті піктограма спочатку.
Ага.
Так, я начебто так і робила.
А нам чомусь нічого не показує.
От, а в мене йде, так, я так і все
Пані
виконувала.
Леся, пані Леся, ви коли вибираєте поділитися екраном, то
Так,
ви вибираєте екран. Ви вибираєте не вашу презентацію, а ви виберете
Гаразд.
екран.
гаразд.
І тоді те, що бачите ви, то буде бачити і вся аудиторія. Ну, я зараз так
Мгм.
зробила прям. Я просто...
And so, when we talk about their environmental safety, yes, very important norm of national legislation is that environmental safety requirements also must be observed during the deployment of military units, military exercise, different movement of troops, military equipments, etc. And it's very important to emphasize that this norm was included to national legislation before the war, before the full scale, of course, and now it's look for me more like a guarantee, some guarantee of environmental safety measures, but in real life we understood that it's very difficult to follow this norm and to implement this norm. In realities of the martial law, priority goals are defense of the country, defense of their territory, saving of life of citizens, their property, and in such conditions, very often we can hear that environment is so-called silent victim of military operation, and at the same time, it's very important to emphasize that the state of natural object, the state of the resources has direct influence on our life, on our health, and other human rights. For example, when we talk about right for health, right for life, for well-being, all of these rights, human rights, depend also on environmental safety. So the next right is the right of free access to information about the environmental situation, and the concept of environmental information was determined in national legislation as a result of different international processes, as a result of signing of a convention on access to information, public participation, and decision making. And on access to justice in environmental matters, as Aarhus Convention. And what does it mean, environmental information? Information about the state of the environment. According to legislation, it is any information in different form. It can be written, audiovisual, electronic, or other materials form about the state of the natural environment and its component, land, water, subsoil, atmospheric air, etc. It also information about biological diversity and its component, different sources, factors, materials, substances, products, energy, and different other factors then affect or may affect the state of the environment and human health. Also, this information includes data about, for example, environmental plans, programs, measures, state policy in the sphere of environment, expenses related to the implementation of environmental protection measures, and different information about sources of financing such measures, economic analysis conducted in the process of decision making, etc. And when we talk about access to information, for us, like for citizens, it's important to understand how we can receive such information. And there are two main methods, two main ways of it. First of all, we can talk about so-called passive methods, when, for example, information providing upon our information request. According to legislation, every citizen of Ukraine has the right to make such request about environmental information, and according to the established period, receive the answer of this request. And the second way is so-called active methods of providing access to information. It has the place when we talk about a systematic and prompt publication of information, for example, in different official platforms, official websites, maybe some special platforms. And it looks more like obligation of authority, local authority, and in some ways business entities to inform population about a state of environment. And when the war started, this right of free access to environmental information was restricted, because access to a lot of register, a lot of different map, different other platforms was restricted. And for example, I show there some of such sources, like a register of login tickets, public cadastral map, a single state register on environmental impact assessment, and other. And for us, like for citizens, it maybe it looks that why access to such register are so important. But when we talk about such procedure like public control, which are made by public activists, by journalists, by scientists, also we can use this information in our, for example, scientific activity, etc. It's very important to have such access. And scientists, public activists, journalists started to say that it's such restrictive measures of access to environmental information, even in the condition of war, are not justified. And thanks to such active position, today we have different situation if to compare with the situation in the beginning of the war. For example, we have opened the register of lodging tickets. We have partly opened this single state register on environmental impact assessment, and when we talk about the public cadastral map, it is closed according to the safety component. But if you are representatives of some public organization, or when you are working in this sphere, for example, when you are representatives of a local authority, etc., you have such access according to special procedure. And when we talk about the next rights, right to compensation for damage inflicted through the violation of the right to a safe environment and other environmental rights, first of all, I'd like to say about the national legislation and mechanism. Such mechanisms are different when we talk about the peacetime and when we talk about the wartime. When we talk about regulation of such relationship in peacetime, we have Court of Ukraine on administrative offenses. We have a Criminal Code of Ukraine, which includes special chapter criminal offenses against the environment. And also, in addition to this, there are special procedure of compensation for damage caused to environment by such offenses. But talking about the wartime, we have special article in Criminal Code of Ukraine, article ecocide, and it included to this chapter criminal offenses against peace, humane security, and international legal order. And also there are special procedures of compensation for damage. Of course, it is understandable because when we talk about damage, the character of damage caused, for example, when some business entities, for example, polluted water resources or other natural objects, the character of such damage is different when we talk about such pollution in the condition of war actions. And also talking about the ecocide, what does it mean? Ecocide is a mass destruction of plant, animal life, poisoning of the atmosphere or water resources, also as well as committing other actions that can cause an ecological disaster. And according to national legislation, such offenses shall be punished by imprisonment for a term of 8 to 15 years. For us, also, it's very important to talk about the mechanism, how we will punish such a person, or in our situation, not person, state, for this action. And it's very important to define who can be plaintiff in such situations. According to national legislation, every citizens of Ukraine, public natural protection organization, also the state environmental inspections of Ukraine and its bodies, individuals and legal entities who have been harmed by criminal offenses, has the right to apply to the court with claims, and has the right to for compensation of damage caused by such actions. What does mean environmental damage? Environmental damage includes different costs. It can be expenses incurred by the state in connection with causing damage to the environmental objects, also costs that must be incurred by the state in the order to restore the normal state of the environmental that existed before damage was caused, and also revenues that the state could realistically receive under normal circumstances. It can be loss from ecosystem services, and also compensation in the case or when it is impossible to restore a natural object because such objects completely lose. Also, it's very important to talk about defendant in such situation. Of course, in our case, we can say that appropriate defendant is Russia Federation, and when we talk about responsibility of the state, we have to understand that we will work through some state bodies, and in our situation it can be the General Prosecutor's Office of the Russia Federation or Ministry of Foreign Affairs of the Russia Federation, but there are different cases. For example, when we talk about the General Prosecutor Offices of the Russia Federation, this body is authorized to represent the interest of the Russia Federation in disputes about compensation damage caused by the RF as a result illegal action on the territory of Ukraine according to lawsuits only by individuals and legal entities. And when we talk about the state and international organization, such authorized body is the Ministry of Foreign Affairs of the Russia Federation. Also, according to national legislation of Ukraine, according to the law of Ukraine on international private law, unfortunately, filing a claim against the foreign state, involving this foreign state in participating in the case as a defendant or even as a third party, we need the consent of this state. And of course, in our situation, we understand that Russia will not consent to be a defendant or to be a third part in such, in any case, yes. So also it's very important to say that Ukraine determine any diplomatic relations with the Russia Federation. We have the possibility to make requests, for example, to embassy of the Russia Federation in Ukraine. And it's very important to emphasize that according to Russia Federation, a foreign state doesn't have such immunity when we talk about the damage caused by the Russia Federation. And it's very important to emphasize that these changes were made in Russia legislation in December, in the last of December 2021, before the war before they start war. Also this juridical immunity based on international documents, we have the possibility to see two conventions, the European Convention on State Immunity and the United Nations Convention on Jurisdictional Immunities of State and their property. But according to these conventions, in case which relate to the monetary compensation in the event of death or some bodily injury person, damage to property, or its loss as a result of action or inaction of the state, in such action or inaction took place in whole or in part of the territory of the state in the card. But at the same time, we have the possibility to restrict such juridical immunity. We can in such so-called situation like a delict exception or turn exception in international law. It calls such, and such restriction in international law gives the possibility in the case when we talk about damage for human life, for property, for compensation of damage, to restrict such juridical immunity. And also, according to the resolution of the Civil Cassation Court of the Supreme Court of Ukraine, considering the case in lawsuit against the Russia Federation, recognize the rights to ignore immunity of the country of the Russia Federation, and consider cases of compensation damage caused to an individual as a result of the armed aggression of the Russia Federation. At the same time, in my opinion, it will be very difficult to talk about some compensation through the national mechanism and national legislation. And the next part of my topic will be about protection of environment in condition of war. And in the end, I will show some international mechanisms for regulation this question. So when we talk about environment at whole, every day, inspectors of the state environmental inspections of Ukraine record the destruction of the environment and from war actions. And today we have approximately damage about 73 billion euros. We talk only about environmental damage. It's very important to say. And what are the most problems? First of all, there are no special detailed methodology how to calculate all this damage, and even Olena in her presentation also said about it, about the damage caused in the sea. So the next problem, a lot of such actions are not recorded. Of course, today state developed and implement a lot of different platforms for recorded all these actions and all these cases. But it's difficult to check all the information, to register this information, to check if, for example, people, different people gives the same case, yes, and register the same case. And the next problem is a lot of territory of Ukraine are not under our control, and of course environmentalists, people who are working in this sphere, cannot calculate directly all this damage. Also, we can see in this picture the worst impact, such summary. The sources of these pictures is the Ministry of Environmental Protection of Ukraine, and we can see shortly the main natural resources, the amount of damage also, and of course these numbers are approximately on the reason which I mentioned before. So when we talk about damage to the environment, very important to emphasize that all Ukrainian regions felt the consequences of the war. Even when we talk about so-called safe region in the west part of Ukraine, we also have different destroying of infrastructure, influence on their land, of the subsoil, on their water resources, forests, etc. And talking about the mechanism, first of all, we have two branches of international law: international environmental law and international humanitarian law, law of armed conflicts. When we talk about the international environmental law, it is the law of peacetime, and norms of international environmental law have a prevention character and provide for the protection, preservation of the natural environment, and don't define the mechanism of environmental protection during armed conflict. So in such situation, international humanitarian law is a flexible like law that is applied during armed conflict. Of course, very important to emphasize that the analysis of the norm of international humanitarian law shows that principles are used to balance the interest of society in environmental safe life and health and the military goals. Looks like a military necessity justifies the damage caused to the environment. According to this principle, nevertheless, we have to talk about the compensation calculation, the damage and amount of such damage to environmental resources of Ukraine. Okay. As I mentioned before, for me it's difficult to understand how we will talk about compensation and some relationship with Russia Federation in the context of national mechanism. And in my opinion, and in opinion of other scientists, people who are working in practical aspects, it's important to talk about international institutions, and we have such, like, for example, International Court of Justice, United Nations International Court of Justice, and in such context are some problems. For example, the main problem here is the lack of enforcement mechanism, and also this court didn't recognize its jurisdictions in terms of Ukraine's demands for a compensation for damage caused by Russian aggression to the environment. The second possibility, the second way, second institutions is International Criminal Court, and as we know, this court work on their based on the Rome Statute, And at the same time, Rome Statute doesn't provide for such crime like ecocide. And also only persons, for example, political or some military leadership, can be held accountable, but not state at full, not state according to Rome Statute. And also, Russia is not a part of this Rome Statute, and of course doesn't recognize the court's decision. And very important to say that Ukraine also became the part of the Rome Statute only on January this year, 2025. And another international, more maybe quasi-judicial than a political body is the United Nations Compensation Commissions. There is such practice of work of such commission in international cases, for example, in the cases of compensation damage caused by Iraq to Kuwait. And also it's very important to talk about the effect of such mechanism, because such United Nations Commission can be created on the level of United Nations Security Council, and as we know, Russia is a member of which was right to veto. And the last mechanism is, first of all, it can be a separate specialized card based on the ad hoc principles, and also it can be the International Register of Damage and Special Commission for consideration of claims for compensation for damage caused by Russian aggression. It's special tools, and these tools can be most effective. And even I have to say that some works of creation of such international register started. And also, it's very important about when we talk about the compensation to talk about the funds, about the money, and it looks at the funds guaranteeing payments at the expense of including confiscated assets of the aggressor states. So, thank you for your attention. Sorry for some technical problems, and I will be happy to communicate if you have some questions. Thank you.
Wonderful. Thank you so much, Lesia. Thank you, colleagues, and looking forward to hearing questions and discussion. So please raise your hand if you'd like to ask a question or offer a comment or a point for discussion. Volodymyr, please.
Yes, thank you for the talk. Very interesting. So my main discipline is environmental engineering, and I'm not very familiar with environmental law. Mostly, I'm kind of busy with technical solutions, technology development, and things of this nature. And so, what I wonder what you think from your perspective, from your disciplinary perspective, what engineering community, people who collect data, who actually run, analysis, chemical analysis, who do assessment on the ground, how they can help Ukraine currently. What are options in terms of venues for such help, whether it's through professional communities and so forth. Thank you.
Thank you very much, Volodymyr. First of all, in my opinion, it's very important to include of the process of development of such methodology specialists from different sphere. I mean, like environmentalists, engineering, etc. For me, like for lawyers, it's also difficult to talk about some technical aspects. I saw proposition for such methodology of calculation, and it includes a lot of formulas, a lot of mathematic analysis, etc. As I know, today a lot of information collected through special platforms, which I mentioned. But I'm not sure that, of course, it's very important to give for citizens, for example, take a photo, make a fixation of such actions, but it's more like it looks that it helps in some statistic information, not in the context of calculation of damage. As I know, a lot of environmentalists today receive information about damage in the territory which occupied through the special space items. I don't know how it say like measuring in the space. I don't know how it works in even in Ukrainian. Yes. It's very important to talk about such calculation, and for me, like for lawyers, it's very important to make this procedure justified, and make this procedure clear. And honestly, when I prepared my presentation, through few next days, the situation in international level so changed that unfortunately I wasn't sure if we will talk about such some compensation in the future. Unfortunately, we cannot be sure in this. But of course, we have to do our work, and works in the context of legal mechanism. I don't know if I answer clearly in your question, but I tried.
Thank you so much, Lesia. Volodymyr, did you want to follow up?
I just wanted to thank and to thank Lesia and say that I hope we can have further discussions, and welcome to the program. We're happy to have you at Michigan State.
Thank you.
Wonderful. And speaking of Michigan State, let's welcome Dr. Norman Graham, Professor of International Relations at the James Madison College of Public Affairs at Michigan State, who has generously agreed to partner with Lesia in the program. So Dr. Graham, please go ahead.
Thanks very much, and I enjoyed your presentation very much. I feel like a junior partner on this because you know so much more about this than I do, but I'll try to catch up. But one of the things I was wondering about, I'm about to run off to my honors college seminar of reading a book about 13 students, very talented, in my course on the politics of international economic relations. And we're reading this book by Stephanie Baker, Punishing Putin, Inside the Global Economic War to Bring Down Russia. And I wondered, in the context of this notion of putting on sanctions and freezing assets and the like, whether you touch it all on or you plan to touch in the future about the prospect of accessing frozen assets to provide actual money that is formerly Russian. Maybe it will always be Russian, but nonetheless, is that a possibility for paying these damages that you've so carefully cited.
Thank you. Thank you very much. I think this book will be interesting for me also. And in my opinion, such funds for compensation must be created earlier, and it will be like guarantee for us for compensation of different damage, not only damage caused to environment, but as we know, it's all question are regulated according to law, which Russia always didn't follow this law. It looks like democratic states try to follow some rules, some standards in the international level, in European level, but Russia Federation doesn't want to do it, and it's difficult to say about some future plan, how it will looks like.
Sure. Thank you. We can talk about this more later, maybe individually. Thank you.
Thank you, Norman. So now Roman has a question. Please, Roman, go ahead. And then there's a question in the chat as well that I'll read out after Roman's question.
Yes, thank you. My name is Roman. I have a question in continue. So I have just reaction comments following the speech of Volodymyr and Norman. So obviously, the ecological damage of Ukraine caused by the Russian Federation is to be part of total reparations from paid from the aggressor side. Meantime, we shall use some proven, recognized methodology to calculate the ecological damages, and maybe we need to investigate if these calculations to be proven by some independent, maybe international agency or some scientific research society to be prepared for this to avoid some misunderstandings from the legal point of view. Just comment, partly already answered. Thank you.
Thank you, Roman. Lesia, did you want to respond at all, or Volodymyr or Norman for that matter?
No, I suppose that maybe we will communicate in such question in the future, because as I know, they are my coordinators. So
Volodymyr?
Yeah, maybe a general point that if you look at how damage is done, sometimes the history of what's happening is important. So a simple post factum analysis may not be sufficient, both in terms of ecological restoration, after the conflict, as well as, of course, the related issue of compensation, some of which I suppose will go towards the recovery efforts, environmental recovery efforts. So I think what's really important and urgent is figuring out the ways of keeping track of what's happening. Because post factum analysis solely may not be sufficient. And this is an engineer speaking. I'm not a legal scholar in any way. So this is also, I guess, why I think it's so interesting, so exciting to hear the opinions of experts in that field. Thank you, Lesia, again, and thank you, Norman. Thank you, Roman, for your feedback as well.
Great, thanks, Volodymyr. Really important point. There's a question in the chat that I'll read out, if that's okay, from our colleague Raymond. Raymond asks, juridically, is there any difference in law between acts done on or against unoccupied Ukrainian territory and acts done on the territory of the so-called Donetsk and Luhansk People's Republics, as well as in those oblasts, partially occupied, claimed by Russia after phony referenda? So, is there a difference in the law between the acts done on occupied territory by Russia, unoccupied, or partially occupied?
Thank you. Thank you very much for such interesting question. First of all, it depends on the status of this territory, which status this territory will have in the future. Today, all this statistic information, all amount of money which I mentioned didn't include this territory, which are occupied more than 10 years ago. Today we talk that, of course, on the one hand, we can talk that such damage also has placed in this territory. I mean, damage for Ukrainian environment. And on the other hand, if Russia defined this territory like they self, in such situation, they have to answer for actions caused in this territory.
Thank you. One more question in the chat that I'll read out from Hannah. Is it possible to claim damage in 10 years from now? Does that type of claim have a time constraint?
When we talk about also this 10 years, of course, we have some research about the damage caused to environment in the context of so-called operation, but when we talk about this special procedure, which I mentioned, special procedure of calculation the damage, it was developed in Ukrainian legislation only after full scale war. So it will be difficult to talk about compensation in the context of all the period of the war action in Ukraine. I don't know how it works in international law in the position. Not I know the practice how other countries compensate this damage, but it needs to compare international and national mechanism. Because, as I said, the national mechanism was developed in 2022, and as we know, the law had strict action in time, and it will be it's interesting question. Thank you, Hannah.
Okay, so thank you so much. Really wonderful questions and lots to think about here. Anyone else have questions for Lesia or points that you'd like to make before we sign off until next time? Matt, please.
Yeah, Lesia, welcome again to Michigan State. I guess I have a question as a historian. It's relatively recent history, but you cited the precedent of Kuwait and Iraq, and this United Nations Compensation Commission, right? So, as I understood it, the final payment was just made in 2022 after a war that began in 1990. So that's quite sobering. So I guess what do you draw from the lessons of Kuwait's claims against Iraq, and is there anything that Ukraine might do differently because of this incredible delay in compensation? And I guess the reality, I don't understand how the commission works. Professor Graham probably does way better than I, but it's also created by the authorization of the Security Council. So if the Russian Federation has a permanent seat on the Security Council, it suggests also that this may never happen. So, what lessons does Kuwait offer us, and are there other precedents that we might point to about the way in which environmental damage incurred during war was remedied?
Thank you very much. It was, I show this example like one of the historical example which are known, and I'm not sure that this commission will be effective for us, and that it is possible to create it for us. For me, the most suitable, the most optimal mechanism is the International Criminal Court. And a lot of lawyers, a lot of environmentalists talked about this procedure of compensation of damage in the framework of this procedure, and reparation not only for environmental damage but other damage caused to civilians, caused to state, etc. When we talk about this example, of course, there was another conditions, yes, of creating of such damage when we talk about the situation with Iraq and Kuwait, but such mechanisms are famous. And so I decided to demonstrate it in my presentation, that it's one of the way of compensation of damage.
Thank you, Lesia. If we can, there's one more very quick question in the chat, and that will be our last one. Raymond is asking, what about more indirect damages caused by attacks on power plants and other infrastructures, resulting in, for example, lack of sewage treatment, lack of potable water, etc.? What are the mechanisms for holding a state, in this case Russia, to account for that kind of damage?
Thank you very much. As I mentioned, environmental damage, this definition tries to include different types of damage, different types of costs, which the state or private person has the possibility to receive in normal consequences. And of course, when we talk about such indirect damage caused by attack on power plants, this question, in such case, State Inspectorate of Ukraine tried to recorded all aspects of damage caused in such way. For example, damage for land, for subsoil, for water resources, and there are different methodology how to determine all this type of of damage, and also damage for example, air and etc. And as I said, even the region in so-called partly safe territory of Ukraine, for example, in the region where I am living, in the west part of Ukraine. But also we have a lot of such attack also on power plants, power station, and all these cases are recorded and calculate the damage. We try to calculate the damage to all of these aspects in indirect damage.
Well, once again, thank you so much, Dr. Danyliuk, for this really informative and such a timely talk. You've really given us a lot to think about. I'll remind everyone that our seminars will continue in March, on March 4th and March 6th. So please mark your calendars. And once again, want to offer our thanks to our two speakers today and to all of our colleagues who are participants in the non-residential scholars program for Ukraine. Really appreciate your work and your collegiality, and please know that we are with you and that we stand with Ukraine and with all of you.